Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
You's a clown, that's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh?
I'm not gonna call you
Look on Facebook Live.
Yes, sir.
Call me a cardboard bishop now.
Yes, sir. Yes, sir.
Clown. That's what you are. You clown. That's what you are. Why don't you say what you said on Facebook Live, sucker?
Yes, sir.
No.
Got it?
That will never get old. Hello, everyone. My name is Pam Esquire, also known as Your Law Intellect. Welcome to all the intellects. If you are new here, welcome. If this is your first time joining us, welcome. Communicate with the chat. We like to go back and forth. And if you've been here before, welcome back. But thank you so much for taking out your noon hour to come chit chat with the intellects. Make sure you be so kind as to hit that like button on your way in so that other people can know that the intellect is on. And also subscribe to the channel if you like the content and you haven't done so already. Today, we are here to discuss Lamor Whitehead. Now, for some of you that may not have heard of him, because I talked about him early on when I started YouTube a couple of years ago. And this sentencing memo, he is up for sentencing on June 17th. He is currently being held. He was remanded, so he is in jail as of right now, awaiting his sentencing, which is coming up next Monday. Now, I knew that the government was supposed to respond yesterday, and they did not drop this memo until literally 11 o'clock last night. And I was just too tired to go live. I set it up. I was ready. And then I was like, I can't do it. I'm just tired. They're going to have to know in the morning what the government had to say. And the government has said a lot. Now, as a few preliminary matters before we get over to talk about Lamor Whitehead, if you guys have been on my community wall, we had a lot of interesting events that occurred yesterday. Many of you guys wanted me to discuss the YSL situation where attorney Steele, who is the defense attorney for Jeffrey Williams, was arrested and held in contempt of court. And so I created a poll over there. I started out because you know how I do. I'm going to make you guys think. I'm not going to just give you the answers on what it is, because I do think a lot of people are responding out of emotion because it just looked like something wasn't right. You know, everybody was like, I don't know what it is, but it don't seem like this is right. But you don't really know why. So what I did for you guys is I know it's long, but I literally cut and paste the judicial code when it comes to ex parte, which means one-sided communication. So you guys can see if, in your opinion, this was an ex parte communication. This is the only way to fairly analyze this case. I think in all fairness, because a lot of us just believe that this whole YSL trial has been a back and forth clownish type of situation. And a lot of the rulings that the judge has made, in my opinion, were not accurate rulings or incorrect rulings. I believe that some people kind of just wanted everything to be wrong. And you guys may be right. He may have been wrong. But I want to make sure that you have your authority. Y'all know how I do over here at PAMU. You got to have your authority if you're going to say these things about him. I've seen headlines about corruption and all type of stuff. Generally speaking, you are not supposed to have ex parte communications, like I said, one-sided. So what allegedly happened is the young man that is on the stand now, I think they call him Woody, Mr. Copeland. He and his attorney, or a standing attorney, and the prosecutor and the judge, they had some type of meeting in chambers. They keep calling it a secret meeting because why was it secret? Because the defense had no clue that it happened. That's why they're calling it a secret. And so somehow Mr. Steele, who is Jeffrey Williams' attorney, said learned from someone about this meeting. And allegedly someone told him the substance of that meeting, of which he believed that as the defense attorney, he had the right to be there. Because as you see from the rule that I put up, ex parte, again, generally you're not supposed to have it, but there are exceptions when it's like administrative type issues or things that aren't very substantive. Well, according to his attorney, Mr. Steele, he felt like the information he got was substantive and he wants to see the transcript. So allegedly, Mr. Copeland asserted his intent back in chambers that he was going to plead the fifth. And the judge responded and said, well, if you do, you're going to be held in jail. You're going to be held in jail for the entire duration of the trial. And this can be construed, according to Mr. Steele, as kind of threat, coercion, or whatever you would interpret it as, that he was almost being forced or compelled to testify, even though he does have immunity. So nothing's going to be used against him anyway that he testifies to. And so Mr. Steele said he was ready to go down for his client. If you have a defense attorney, that's the kind of defense attorney you want. The one that is going to fight for you. And even though there may be some consequences, who really believes in your constitutional rights being protected, that's what he was doing. And what I can say about the Defense Association over there in Fulton County, they wasn't having it. It was over 20 of them that were out there willing to step up and step in to support their brother counsel, who they felt were being wrongfully treated in this courtroom. Now, on the flip side, Miss Merchant, for some of you guys that don't know who Miss Merchant is, she is the lady that brought all this stuff up as it pertains to Madam DA Fonnie Willis, about her having the relationship with Wade and all of that. She doesn't represent Trump, but she represented one of the Codys. And she is the one that brought all of this to light. Now, Miss Merchant, she was fighting the procedures of how the judge conducted the contempt. When it comes procedurally, in my opinion, looking at the rules and the case law, even the case law she cited, I am of the opinion that she was absolutely wrong. When you have when the judge is alleging direct contempt, they do have the right there to summarily make a decision. However, under the case law, they have to allow the person who is being held in contempt, which would have been Mr. Steele, they had to allow him to speak and to defend himself, of which the judge allowed earlier. Now, he didn't buy it and was like, you still in contempt until you tell me who told you what you just said you learned. But he did follow the protocol for direct criminal contempt. He did file a protocol for that. Now, the issue is he was focused on who told, and he's deflecting from the fact that there was literally a ex parte meeting in chambers. I think that's getting lost in the sauce. He was just upset because in his mind, there's a mole. And I got to worry about who is going back telling information that I'm trying to do ex parte. He did not deny that there was an ex parte communication. I think he feels like he protected himself because there was supposed to be a court reporter that was back there. And so, if necessary, the transcript can be given to the other side. So that was what I think his argument was. However, if you guys look at the rule that I posted, Mr. Steele should not have found out about these communications by some third random party. That's not how he should have found out. According to the rule, if it was a substantive or ex parte communication, the judge should have alerted him of that. So it's going to be very, very interesting to see how this turns out. Now, you guys were correct. Miss Merchant came in and she argued these cases that really, honestly, in my opinion, it was more pro the judge and his position on how he was handling the proceedings of contempt within itself, not the substance of what the contempt was for, but just how he handled the proceedings. His wife immediately, while Merchant was standing there talking, apparently his wife was like, because that notice of appeal, I had a copy of that while they were they're still in court. A notice of appeal was filed. There was also a motion for supersedes bond, because if an appeal under the law, if an appeal is filed timely or within a certain period of time, the judge must or shall order bond. So they did a motion for bond because he should have one. Now, the judge, for those of you that don't know, said that Mr. Steele has to come in every weekend for the next 10 weeks until he purges himself, i.e., tells this judge who said what, because that's all the judge wants to know. And clearly, Mr. Steele don't care about kicking it over there on Rice Street, because he said, well, can you make it where I could be, my client's bunkie almost? Okay, he didn't say that, because I think he's in Cobb County. But yeah, so maybe he's trying to flip and go to Cobb County, I think is what's happening now, because the judge ordered him on Rice Street, which would be Fulton County. But we know, if you follow Ernest Williams and what he's told us, Thug is being held over in Cobb. So he wants to be able to still confer and meet with his client on a consistent and a daily basis. So that is all of that in a nutshell, for those of you that wanted my take on it. So I ain't put it on the thumbnail. So if you didn't come here to watch Whitehead, you probably wouldn't know my take. But I just think that a lot of people, is there authority that perhaps he should not have held him in criminal contempt? In my opinion, yes, based on reading the rule. Was his procedures as to the actual contempt hearing correct? From my research, it seems like it was correct how he did it. Now, whether he should have held him in contempt, I think the Court of Appeals will make that decision, and we'll all know soon. But that judge wasn't changing his mind. He don't care what any of y'all. People were all up in attack, calling him corrupt, dragging him, going off. He didn't care. He went back in his chambers, double checked his sites, and made sure he had authority for what he was doing. And he came back like, my decision stands. I don't care who said what, when, where, which way, how. Until you tell me who the snitch is, we got a problem. That's what he said. I have a problem. This is a serious problem. The sanctimony of this courtroom or these chambers is on high alert. You said Fulton County is not a real place. It's very interesting what happens over there in Fulton County. Their rules and regulations are so different. So when you guys ask me questions, I can say generally how I know it to be as far as where I am. But you literally have to look stuff up just to make sure. Now, do I just do a deep dive like it was my case? I do not. So there may be other case law or subsequent case law, but from what I read, the cases that Miss Merchant brought up basically says if you have direct contempt, that for due process purposes, your client has the ability to go in front and to plead their case and be heard. That's it. That's all the due process they really have during that time. Because direct contempt, for those of you that don't know, direct contempt is in front of the judge. Indirect contempt is outside of the presence of the judge. Obviously, he told him no to his face. So that was direct contempt. If it was indirect contempt, then Mr. Merchant would be correct, meaning that there needs to be a whole hearing. He has all the rights of a defendant. He can have counsel. He can put on a case. He can subpoena witnesses, all of that. But when you have direct contempt in the judge's face, which is what he is alleging, because he told him, I'm not telling you nothing. Judge, I don't care. I'm not telling you a doggone thing. Because of that, that made it direct, and he was able to do the process the way that he did. What will this do for his law license with a felony? I'm not sure that it is a felony. And lawyers, believe it or not, get held in contempt. I have a few. Is one guy, he was known for going to jail all the time for his clients here in Detroit. Literally. He would be like, and you have certain passions and you fight vigorously for your client, and there's sometimes a possibility that judges take offense or they feel disrespected, or you said something that they feel like disparages them personally or the court, and they have that power, like they have the black robe. So Lisa said, I can't watch the trial because of the judge. Yeah, a lot of people have said that. I think he may be a nice guy. I've seen some opinions where I think he was thorough. I just think this is an overwhelming case. You have a lot of people that's coming on to testify that clearly don't want to. They don't remember their name, how many kids they have, the birth dates, what street they lived on. They always put up pictures. Do you know that person? I don't know his real name. What's his name? His name is Bush. Bush. You know, like we call him firefighter in the street. Like, it's just such a clown, like such a circus on this case that I just couldn't do it. I was like, every time that I try to watch it, I just end up turning away. Now, this was some excuse me. This was something that was big, obviously a lot of people covered it, even people that weren't covering this case. To watch Mr. Steele get arrested and then watch the unity and of all of the defense attorneys coming to his rescue. And then the judge said, I'm standing on business. He didn't care who was saying what, which way or how. He was standing on what he said. I don't like a lot of the rulings. Has he made some bad rulings? In my opinion, he has in this case. But again, that's just my opinion. I'm not in the role of sitting on the bench and making these knee-jerk or immediate, rather, I won't say knee-jerk, but making these immediate on-the-spot decisions. So he gets them wrong sometimes. I don't like all these comfort breaks and getting up and you be at the court at that's a pet peeve of mine, period. Because when you do defense work, you want people to respect your time because you have a whole day and you have other clients. And oftentimes, if you do defense work, you might have something in multiple courtrooms on that day. And so to have judges that say come at 9:30 and they don't start till like 11, I don't like people playing with my time like that. So I don't like that. I think it's going to the trial is going to be way longer than it has to be because of all of these breaks and like things that, in my opinion, should have been ironed out before the trial started. That's why you have motion practice to try to eliminate some of this stuff. It's just been a lot going on. So again, I literally cannot watch this trial for like 2 weeks and pop back on, and I know exactly what's going on because it's the same shenanigans that was going on 2 weeks ago when I watched it. So for always forever, thank you for the super chat. You said, can this result in a mistrial? Well, it's interesting because there are some things that I have an issue with. One of the things was the judge yelled at Mr. Steele in front of the jury. There have been some conduct of the judge that Mr. Steele could plausibly allege that there is some type of bias. If there is some type of bias and you can prove that, you can either say that the judge should have recused himself, and I think that's what he asked yesterday, and if not, and he conducts this trial and it ends up being a a verdict of guilty, you got appellate issues and you may end up reversed and remanded. So I think it's definitely a slippery slope. Will the judge, I doubt after all this time, he's not going to declare mistrial for any purposes. I don't think he will. Unless it's just so blatant, like somebody talking to a juror or something, and it's obvious they talked to the juror and it's tainted, or something like that. But on this type of stuff, he's not going to. You're basically asking him to say he was wrong about his rulings. He's not. I don't think he's going to do that. But that's just my opinion. We shall see. But thank you for the super chat and the question. LK says she's so Miss Merchant is so, she is, but the judge, which was interesting, asked for those citations, pulled them up, and read the case while on the bench, and they were not on point for what he was doing. So I will say for that proposition, he was right as to how he was conducting his contempt hearing, because he said it was direct contempt, which is in the courts, in the presence of his face, the court's face, instead of indirect, which affords you more constitutional protection, because it's a he said, she said. If it's out of that means that a third party told the judge something because it wasn't in his face. So it's very interesting for sure. I don't know Ashley Merchant's rate, but her rates might triple after all of this is. Thank you so much, Ronald Lucas. Yeah, I'm not that impressed with her. I mean, I watched the stuff with Madame DA, with that and the questions she was asking, and the fact she was able to even shake the table and she was able to delay. I mean, she was able to, it's in the Court of Appeals, and now the case is stayed until the Court of Appeals make a decision as to whether Fonnie Willis and her office should be allowed on the case. So she did her thing to do that for those purposes. But when I was listening to a lot of the arguments, I was like, okay, it's just kind of, as a lawyer, you find gray areas, and your job is to make it work for you. Like, you bend the law. It may not have been read that way, but maybe one word will help you for your plight. So she does her little, her thing. But when those cases she cited yesterday wasn't, the judge was right. I would have to agree with the judge on how he interpreted those cases yesterday. Caramel QT said, I'm embarrassed to live in Georgia right now between Trump, Fonnie, and every lawyer on Thug Strap. They got some good lawyers there. I have some friends that work in Fulton County that are on the defense and on the DA side, and they are very good. They are very good lawyers. It's just they have an interesting system, and I think Fulton County is being highlighted. So now a lot of us that had no clue of all of the shenanigans that go on or their rules and regulations, we are like, huh? So for some lawyers, I think they're happy about that. Like, now the rest of the world can see what the foolishness we've been dealing with all these years. Afternoon to you, Randy Intern. Thank you for being a member for 4 months. I appreciate you. So yeah, let me see. I think we had, thank you, Bishop B, for becoming a member, and name change for 12. Thank you so much for gifting 5 memberships. Welcome to all of the new intellects. I appreciate you. And then for those of you that have not heard, Hunter Biden, who is the son of our now president, Joe Biden, has been convicted of all 3 counts, which seemed a little bit obvious to me that he would be. Joe Biden alleges that he is not going to pardon him because this is a federal case. He does have the ability to pardon his son. Unlike Trump, which was a state case, he can't pardon himself. Only a governor of that state can do that. So the question was obviously asked before the verdict, when Biden was sitting down, whether he was going to pardon him, and he basically said he would not. Now, my position is you can only run for president twice anyway. So once you get up in office, what they gonna do if you do? But hey, They just gonna call you a liar or something. I mean, we all think politicians ain't all the way honest anyway. And we could look at Biden's history, and I ain't gonna go all the way there, but he ain't always been on the right side of justice, in my opinion. So we shall see how that goes. Do the jurors get a special stipend? This trial is long. Jesus, I only get 10 days in California. This is sad. They get that same. I think one time they were asking for lunch or something, and that was a problem, like for them to pay for lunch. This is literally over a year of their lives that's going to happen. This is going to go well into 2025 at this rate, which is another reason why I was like, I'm not covering this. Like, who has time? Like, if I could just stream it while I'm out and about and let it go while I'm in court or something, then I would do it. I had to do that with the YNW Melly, but it obviously wasn't nowhere near this long. Then yeah, but yeah, I feel you. I think it's a hardship for any juror. Any juror. It's crazy. Woody is mildly MR with vision issue while he testify. Is he? I don't know if his attorney asked for a competency hearing of any kind. I mean, just because you're mildly your MR doesn't necessarily mean you can't testify, or you can't testify to what you know, because that's all you're saying you're doing as a witness. But I haven't looked at his testimony. I clicked on for a minute and seen them asking who are the people on the picture. I promise you, every time I click on it, seems like they asking the same question, asking people about pictures and who they are, because they're in pictures with these people that are the defendants. He's like, start from your right. Start from is it my left or your left? My right or your right? I was like, this is the same stuff. Every time somebody gets on here, it seems like they say the same thing. How does the state expect people to remember what happened in 2012? I can't remember what I had on yesterday. I agree with you. I think your best memory is around the same time something happens. Testimony evolves, or you forget things, or, I agree with you. I think it's very difficult for these people to remember every little thing that they were doing back then and who they were with and when they were around them. But I think this was a big case for them to take on like this, in my opinion. But Lisa said, I'm scheduled for jury duty next month, and I'm going to need my doctor to help me with not going. We don't want to do jury duty. I thought I made you guys want to do jury duty, because they'll never, like, lawyers. Usually, that's why I was crazy on the Trump trial. They had 2 lawyers. Typically, they find out you're a lawyer. I don't care how you phrase it. You can say, I'm in the legal field. Well, what exactly do you do? I draft pleadings. You could try any way that you can do it. They're like, oh, so you're a lawyer? We like to thank and excuse juror number 2. You are getting excused immediately. They do not want, a lot of times they don't want it because they know that a lot of lawyers are analytical. And they will look at both sides. Even though they'll tell you don't act on emotion, I think oftentimes they do want you to act on emotion. So yeah, I don't even get, they don't even ask me to be on the jury. I'm like, it's very rare they even have lawyers on their juries. I wanted to be a juror on the Mosby case. That would have been interesting. In Tennessee, 3 months jury duty. That's how federal court does it. Once you get summoned for jury duty, you're on call for a certain amount of months. But yeah. All right, y'all. So we done spent about 28 minutes talking about everything going on in the news that I posted. So let's get into it. I want you guys to hit that like button, subscribe to the channel. As I stated before, Lamor Whitehead, we went over on the last video related to him, his sentencing memo, but we have the government. So let's get into it, because baby, the government was not playing not 1 ounce of games with anybody. And let me see if this is the one. Yes. So when I pulled this up last night, I said, Lord, they got a table of contents. This is about to be some reading here, okay? As you see, they have a table of contents, so you can go directly to the parts such as the defendant's ongoing lies, the Pauline Anderson fraud over there on page 3, the defendant's violation of the protective order, page 10. I said, oh, so this is serious, okay? It's going all the way down, Andrew. That's what I knew when I saw the table of contents. I said, oh, okay. It's going all the way down. It's going down. Okay. So let's get into the preliminary. It's 1,000 of you in here. Hit that like. Welcome. Welcome, everybody. The preliminary statement, I'm going to read this with as much emotion as I can. It says, Lamor Whitehead, the defendant, is a career con man and liar who has been committing frauds for over 20 years to finance his extravagant lifestyle. On March 11th of 2024, Whitehead was convicted following a jury trial of all 5 counts of indictment S122CR692. So that is the case number, the indictment. For defrauding a church parishioner, defrauding lenders, attempting to defraud a businessman, attempting to extort a businessman, and lying to federal agents. And committing these crimes, the defendant abused his position of power and trust as a religious leader, lied about his finances, doctored numerous bank statements, and threatened victims, among other things, in order to obtain over $7.2 million. Whitehead held himself out as a wealthy and successful, quote, real estate investor, end quote, and quote, profit. Not a profit. I was like, a profit. Did he say he was a prophet, y'all? When in actuality, purchased his home and an investment property through fraud and with fraud proceeds, reported annual incomes to the IR and the S between $5,000 and $13,000 in tax years 2017 through 2019. This man, according to them, between 2017 and 2019 did not claim more than $13,000. How are you donating $25,000 to Cookies and them and your income don't even exceed $13,000? I need someone to help me with the mathing. And now he claims he only has $181.54 in the bank. Then, how are you going to challenge DL Hughley and them to $1 million fights and you got $181.54 in the bank? Despite his prior arrest, 4 criminal convictions, and lengthy prison sentences, the defendant has remained undeterred from committing crimes. Even after the indictment was filed, the defendant brazenly lied under oath before the jury in this court. He has continued to lie to the public even after the jury's guilty verdicts, including by making patently false allegations about the prosecution and the evidence that proved his guilt beyond a reasonable doubt. He even tried to sell discovery material online in violation of the court's protective order to further profit from his crimes. Whitehead's crimes, for which he has shown an utter lack of remorse, has substantially harmed numerous victims and the community at large, including hardworking individuals and church parishioners, lenders, and financial institutions. The government, y'all listening? The government respectfully submits this memorandum in advance of Whitehead's sentencing in response to his June 3rd, 2024 sentencing submission. The applicable range under the United States sentencing guidelines is in dispute. In the government's view, the range is 151 to 188 months. What's 188 months? Because they don't even agree with pretrial services. They said it's higher. Let's see. That's 15 years. Didn't I tell y'all 10 to 15? So that's what the government said. Basically 10 to 15 or 12 to 15. imprisonment, but the probation office has calculated an applicable guideline range of 121 to 151 months imprisonment. For the reasons set forth below, however, the court resolves the guideline dispute. 151 months in prison is the sentence sufficient, but not greater than necessary to achieve the purposes of sentencing in this case. So the government that's asking that Lamor Whitehead be sentenced to 151 months in prison. In addition, the court should impose a fine and order restitution and forfeiture as set forth below. The extraordinary leniency requested by the defendant, who seeks an effective sentence of 4 weeks in prison and a term of supervised release, fails to address his repeated crimes, the needs for specific and general deterrence, the seriousness of the offense, and the needs for just punishment and promote respect for the law. Further, there is no basis for bail pending appeal. Okay, that the government has spoke. That is their opening statement. Okay, the preliminary before they even get into anything. So we all know how the government feels. Okay. Let's move on. Let's go into the crimes, the background. So for those that did not follow this case, this is going to help you know what he is accused of, the loan fraud. In 2018, Whitehead began committing a series of virtually identical frauds against a variety of banks and other lenders. The first of these frauds was charged in count 5 of the indictment. As the jury found at trial, Whitehead submitted a fraudulent application seeking $250,000 business loan to the loan broker Fundera, which passed the application to PayPal, a potential lender. Whitehead's fraudulent application claimed that a company he owned, Anointing Management Services LLC, earned $6 million in annual revenue and had an average bank balance of $1 million. The application was accompanied by doctored Wells Fargo bank accounts that falsely reflected that Anointing Management Services had millions of dollars in the bank. PayPal identified the application as fraudulent and did not issue the defendant a loan. Other lenders were not as lucky. The defendant's loan fraud continued using the same shell corporation and the same phony bank statements with the same fake inflated balances for years. He submitted similar and overlapping falsified Wells Fargo statements and made similar false claims about his and his entity's earnings to at least 5 other lenders over the course of about 4 years. In February 2019, Whitehead applied for a mortgage loan on the mansion in Paramus, New Jersey, that he still owns today. Well, no, he doesn't. That went up for sale. ADA, that went up for sale. That application, like the Fundera and PayPal application, was supported by a series of fraudulent Wells Fargo statements for Anointing Management Services. But unlike the Fundera application, that application was successful. The mortgage lender issued Whitehead a $1.3 million mortgage in reliance on the defendant's fraudulent application. In October of 21, Whitehead applied for a home equity line of credit in the same Paramus home, this time from a different lender. This application, just like the defendant's original mortgage, was fraudulent. Now, these are the ones that the government did not charge him with, but they talked about it during the trial. Because the Fundera, which is what he was actually charged with, they didn't get the money. They was like, they flagged it and was like, something ain't right with this. So they didn't give it to him. But all these other lenders, they gave it to him. This time, Whitehead also submitted falsified IRS forms, and the fraud again worked. Whitehead received $500,000 home equity line of credit based on the false application. In November of 21, Whitehead submitted another fraudulent loan application to another lender. This application, like the others, used phony Wells Fargo bank accounts and false claims that Anointing Management Services was a multi-million-dollar business. And based on this app, Whitehead received $4.15 million commercial loan. He used that loan to buy a building in Hartford, Connecticut. That is now in foreclosure proceedings. So that is the Connecticut property that's in foreclosure. In addition to these loan applications, which netted Whitehead almost $6 million in fraud proceeds, Whitehead also submitted a fraudulent application for another $1 million home equity line of credit and attempted to defraud another lender by sending a fraudulent proof of funds email attaching another phony Wells Fargo statement. All told, the defendant's loan frauds involved a total actual plus intended loss of more than $7 million, most of which was actual loss. Nor has Whitehead paid back the lenders he defrauded out of almost $6 million. The mortgages on both of his properties and the home equity line of credit he fraudulently obtained on his mansion remain outstanding, and he reported to the probation office that he is not making payments. He's like, yeah, I owe it and I ain't paying it. Now we get to Pauline Anderson, who has also submitted a impact statement as well. It'll be interesting to see if she actually makes the statement at the upcoming sentencing. Let's get into Pauline Anderson. This was another charge in conviction in the indictment. Not content resting on the multi-million-dollar loan frauds, Whitehead also defrauded one of his parishioners, Pauline Anderson, out of $90,000. And his argument is, she was not my parishioner. She was not my parishioner. We like, but did you take the money though? Let's just say she was just random on the street. Did you take the lady's money? But she is not my parishioner. That was his argument all over the internet. Miss Anderson met the defendant in January 2020 through her son, Rashid Anderson. Mr. Anderson was a volunteer member of the defendant's church staff, and he brought his mother to Sunday service at Whitehead's church in Brooklyn. After seeing her son buy a home with Whitehead's encouragement, Miss Anderson began seeking and relying on advice from the defendant about potentially purchasing a home of her own. She decided to withdraw money from her retirement account and to find a down payment, and made a plan to withdraw $50K. But when she called the financial institution that held a retirement fund, Whitehead joined her in the call and urged Miss Anderson to withdraw $100K instead of the $50K she had planned. At Whitehead's urging, Miss Anderson did so. So she originally was only going to take $50,000 out. Whitehead was like, no, Miss Anderson, you should just go ahead and take out that $100,000. Then Whitehead stole most of that money. The defendant arranged for Miss Anderson to speak to two potential lenders, both of whom told her that she did not qualify for a home loan. When she reported this to Whitehead, he responded by offering to get Miss Anderson a home. He told her that if she gave him the money that she had withdrawn from her retirement account, he would use it to buy her a home. Relying on that representation, Miss Anderson said, "Here you go, Whitehead, here's $90,000 by check on November 2020. Almost immediately after receiving Miss Anderson's money, Whitehead began spending it on himself. He used it to buy luxury goods, to shop at Polo and Louis Vuitton, to make car payments to BMW, to buy furniture, groceries, and food deliveries. There was some Door Dashes on there, like about $3,000. I'm like, dang. To pay for travel and to make substantial cash withdrawals and transfers via payment application like Cash App. By early 2021, the defendant has spent most of Miss Anderson's money on these personal expenditures, and Whitehead did little or nothing to help Miss Anderson find a home. When in May 2021, Miss Anderson said, "Can I get my money back?" Whitehead could not pay it back. He no longer had it. So he made a series of increasingly ridiculous, fraudulent statements to Miss Anderson. He told her that there was a contract that allowed him to keep the money. He told her that he had invested the money, so it was tied up. And he claimed that he was not able to pay her back until after the campaign for Brooklyn Borough President ended, of which he was like last in place, might I add, in that Brooklyn Borough President. And he has a judgment against him for one of the campaign workers that he didn't even pay. I just added that. The government ain't say that. I said that. These were all lies. In reality, there was no contract. Whitehead had spent, not invested the money, and there was no bar on his paying her back during his political campaign, nor did the defendant pay Miss Anderson back after he lost the election. When Whitehead's lies did not cause Miss Anderson to back off her request for reimbursement or quiet her suspicions, he began threatening her. Whitehead threatened lawsuits, threatened to come after Miss Anderson and her son's jobs, and claimed that God would harm the Anderson. He told them, "Touch not my anointed," when she said, "I want my money back." The Brandon Belmonte extortion. This is another count that is in there. You guys all right over here in the chat? I'm not surprised by Bishop Flashy Flash. Okay. Scam from the start. He didn't even get her qualified for a home loan before withdrawing her retirement money. Gigi said, did he cash out some IG models? I don't know. I seen a screenshot where he liked their posts or something. But Miss Walker said he couldn't convince me to do anything with that slick pimp talking. You'll be surprised. People you guys seen them letters? There are literally people out here for some reason that believe he somehow railroaded. I don't know. Rally says so. He spent that lady's money on them noisy art suits. Well, the Louis Vuitton, some of it appears at least partially to be real because they came from the Louis V store. It came up on the bank statements. We saw it in trial. I Am Unique said, is she going to get any of her money back? Like how? I think the only way she'll get her money back is if he got to stay on probation or something until he pays back restitution, if they order restitution. But he don't have any money. He just said he got $100. You didn't. I just read the man got $100 and something in his bank account. How is he going to pay her back $90,000? That math don't math now. Let's proceed. The Brandon Belmonte extortion and fraud. The defendant was also convicted of attempting to defraud and extort Brandon Belmonte. The extortion charged in count 3 occurred earlier in time in February 2022. The defendant bought his wife's Mercedes-Benz G-Wagon into a body shop Belmonte owned. In connection with that work, Whitehead claimed that Belmonte owed him $5,000. Whitehead made violent threats to try to collect on that purported debt. Angel Fernandez, who worked as Belmonte's driver, testified that he saw a nearly physical altercation between defendant and Belmonte at Belmonte's body shop. Fernandez saw Whitehead screaming and cursing at Belmonte. The defendant was swinging his arms and looked as though he was going to hit Belmonte. He was like all up in his face, is how Fernandez said it. He was like, he was all up in his face. And Belmonte was allegedly real submissive and just had his hands like, I'm not even going to do nothing. The defendant was swinging his arms and looked as though he was going to hit Belmonte. Later, Whitehead effectively confirmed this account by making adoptive admissions of statements Belmonte made and recorded conversations. Specifically, in an April 29th recording, Belmonte told the defendant, "You got in my face and I thought you were going to crack me. I was convinced you were going to crack me." The defendant responded by... So yeah, there was a recording of which Belmonte talked about this incident, of which Angel Fernandez testified to and said, "I thought you was about to hit me when you was in my face." And then, Whitehead was like... In March and April 2022, Whitehead repeatedly demanded the $5,000 from Belmonte, including through text messages and phone calls, and threatened Belmonte with harm if he did not pay, stating he would hurt Belmonte. For example, in a recorded conversation on April 23rd, the defendant repeatedly threatened violence to Belmonte if Belmonte did not pay the $5,000. Whitehead said, among other things, that Belmonte was not, quote, gonna play with me, end quote, and told Belmonte, quote, "I will hurt you," end quote. Whitehead went on to say, quote, "There's guns in my church," end quote, effectively threatening to shoot Belmonte if he did not pay. Belmonte ultimately delivered the 5K to the defendant using cash supplied to him by the F, the B, and the I. Thereafter, as charged in count 2, Whitehead attempted to defraud Belmonte. Belmonte was acting at the direction of the FBI at the time and agreed to wear recording devices to meetings with the defendant, and also created recordings of certain communications with the defendant himself. In those recordings, the defendant told Belmonte, among other things, that he had, quote, the key to the city, end quote, and that New York City Mayor Eric Adams would, quote, tell me where the money is, end quote. The defendant claimed that the mayor would help the defendant obtain permission from New York City to operate residential housing at affordable housing without actually doing so, and to get stop work orders lifted on real estate development projects. In exchange, the defendant told Belmonte that Belmonte would need to transfer ownership of real estate holding to the defendant. The defendant also sought to help Belmonte give the defendant $500K. But the defendant claims that he could not obtain favors from the mayor were false. Obtain favors from the mayor were false. Although the defendant had a mentoring relationship with Mayor Adams, he knew he could not obtain favors from the mayor, who would not assist the defendant with personal disputes, would not take action for the defendant, and would not even attend the defendant's birthday party. In fact, in February 2022, approximately 2 months before the defendant told Belmonte about his repeated influence over the mayor, the defendant wrote to the mayor complaining about his lack of access and his inability to get a meeting. The mayor did not respond. The defendant lies to the FBI. On the morning of June 8th of 2022, FBI agents went to Whitehead's Paramus home to execute a search warrant. The warrant authorized the seizure of cell phones on the defendant's person, and agents seized one phone and a call number ending in 3314 from Whitehead's based on the warrant. While speaking with Whitehead in the driveway of his home, the agent repeatedly asked the defendant whether he had other cell phones. Whitehead repeatedly told the agents that he did not. He claimed that when he repeatedly went into his home to make phone calls or retrieve information, he was using his daughter's phone, not his own. And he said that he did not have another cell phone. Those were false. In truth, Whitehead's other cell phone with the call number ending in 9839 was right inside his house that morning. Those lies were material because, among other things, had Whitehead told the truth, the FBI would have been able to obtain a subsequent warrant that same day to seize the other phone. Instead, the FBI obtained a second search warrant to seize the phone later that month. The defendant's ongoing lies. The defendant lies on the stand. Somebody said, was that Belmonte he was calling a clown? No, that was actually a pastor. He was getting an eviction notice in that video, and they handed it to him, and he got mad, and he was calling him a clown. I think that pastor actually passed away now, but I think he might have been renting the space or something for his church. But yeah, let's talk about the lies on the stand. At trial, the defendant testified and he committed perjury by lying to the jury and the court under oath. For example, the defendant testified under oath that he did not submit the fraudulent loan applications to Fundora or any of the fraudulent Wells Fargo bank statements to various lenders. As the jury found in convicting the defendant on count 5, and as the trial evidence overwhelmingly established, these statements are false. The defendant testified under oath that he never had any conversations with Pauline Anderson about money or anything. This statement is false. In actuality, the testimony of Pauline and Rashid Anderson, as corroborated by cell phone records, established that the defendant participated in multiple conversations with Pauline Anderson about money, including a call with Miss Anderson and Transamerica in July 22, 2020. The defendant testified under oath that he did not file taxes for tax years 2017 through 2022 because his identity had been stolen. Like, who want to take your identity right here? Like, seriously. You don't even want your own identity. You change your name from Lamar to Lamor. His name, let me see. Hold on. Let me see what his name was when he was convicted the first time. Let's see here. Oh, let me pull this up. Let me see what the top of this thing says. I'm not, what is your name, sir? Like, what is your mama name you? That's what we want to know. Okay, let's see. Yep, this is the sentencing transcript from when he was sentenced on June 30th of 2008. In this thing, it says Lamor with an A. Whitehead. That was your name back in 2008 for sentencing. When you was convicted the first time. Now your name is Lamor. So if you don't want your own name, why do you think somebody else wanted it? That's just something that we just need to ponder for a little while. But let's go on. He said his identity was stolen and that any tax documents would have been prepared by his accountant, Israel Vasquez. These statements are false. Documents obtained from the IRS, including certain documents received after the jury's guilty verdict, established that the defendant did, in fact, file tax documents for tax years 2017 through 2019, and that these documents have been self-filed by the defendant, not filed by an accountant. So they went even after the guilty verdict. And they said, let me go put in a transcript and ask to see like what his taxes say. And it ain't got no Vasquez on there. It has him as filing his own taxes. Then the government says, then you turn around and you lie to the public. Of course, the defendant has the right to claim innocence, including post-conviction. And speaking publicly about the case, however, both before, during, and after the trial, the defendant has repeatedly made statements that are simply false. And the defendant has repeatedly and falsely claimed that the investigation and charges against him were motivated by race and or politics and were for the purposes of retaliation because, according to the defendant would not provide information about Adams. For example, on March 10, 2023, in media interview after his arrest in this case, the defendant falsely alleged this case to be an attack on the black man. And this is more of a political attack. You see, the world knows that myself and the now Mayor Eric Adams are very close. I'm collateral damage. See, I bet y'all ain't even know that, did you? Okay, I added that because that's what he usually says after that. I'm a young black pastor that come from a broken home. My father was beaten and strangled to death by 16 police officers because of the color of his skin. I was sent away to prison back in 2008, illegally, fake search warrants, all different types of things that we black men have to go through. It's just the real life. We talk about how the police kill black men, but we don't talk about how court documents and court paperwork and prosecution kill black men. And they not only destroy us financially, but they kill our credibility. And this is what you are seeing happening to me right now. On or about March 12, 2024, the day after the jury's guilty verdicts, the defendant posted a video on social media falsely claiming that he was wrongfully convicted and that he was being retaliated against because he would not provide information against Adams. The defendant falsely alleged, quote, "This wasn't about me. I was not going to be an informant for the FBI against the New York City Mayor Eric Adams." Something tells me that if you could avoid prison, you would have told whatever you knew if you had something to tell. I'm just saying. That's just my spidey senses tell me that because you don't give no dang about nobody but your own self, you would definitely tell if you had some information. You just ain't had nothing to tell because Eric Adams wasn't even messing with you. On or about April 18, 2024, the defendant made false statements in a podcast interview, including the following. Shout out to Jamal Bryant. The defendant falsely stated that while executing a search warrant for his cell phone, the FBI told him that they wanted him to help them with the mayor while executing search warrants for the defendant's phone. The FBI told the defendant, quote, "We're going to slam you on the floor. We're going to put your face there. We're going to bend your fingers to make you open the phone." An FBI agent, quote, lied on 6 warrants to the judge. And 4, the FBI didn't have nothing on me. And so the FBI had to orchestrate, because you can't say orchestrate. He probably said orchestrate, and turn Miss Anderson's civil case into a criminal matter. Since I'm not working with the FBI to take down the mayor, they made this into a criminal matter. The defendant's allegations are patently false and belied by both the facts established at trial and by the procedural history of this case. Notably, the defendant did not file any motions alleging selective prosecution, nor could he have. Such a motion would have failed because there is not a shred of evidence that the defendant was prosecuted because of race, politics, and or retaliations. Now they say the defendant's violation of the protective order. I told y'all this was thorough. If you didn't know anything about this case, once you read this, you're going to know everything you need to know about this here case. The defendant's violation of protective order. Following his conviction, Whitehead went so far as to try to sell, quote, exclusive paperwork, end quote, i.e. materials produced by the government to the defendant, in violation of the court's protective order. On April 30th, 2024, the defendant posted a video to YouTube entitled "Fight for Justice. Bishop Whitehead exposes alleged FBI misconduct." In the video, defendant read from and waved around multiple documents that were produced in discovery subject to the protective order in this case. For example, about 18 and a half minutes into the video, Whitehead extensively read from the FBI's 302 documenting, I said 302, documenting an interview with one of his victims. And approximately 25 minutes into the video, Whitehead read from another 302 of an interview of the victim. There were other documents, including search warrants and search warrant return documents, that Whitehead likewise waved around and directly quoted from during the video. Under the protective order, the defendant was prohibited from using the documents for any purposes other than to defend this case and was not permitted to publicly disclose them on YouTube. The defendant's remarks in this video make clear that he understood that the documents could not be permissibly disclosed. While waving around the second document referenced above, he said, "The jury could not get to this at all. You guys could not get this at all. This is exclusive paperwork. This right here is exclusive paperwork." Whitehead also indicated that he intended to make the discovery material he was reading from available for purchase online. And all of this paperwork, we will have it in the Patreon. Bishop's Patreon, where you can go and you will be able to see the paperwork. So what I'm showing you, the media, not the Daily News, not the New York Times, not NBC, not CBS, not World News, not CNN, nobody has this paperwork. And this paperwork is going to be the reason why this case will be reversed and overturned, right? Right? And you guys have been destroying my life because the jury was not able to see this here paperwork. Then they go on to the defendant's false statements about his finances, including to the probation office. Y'all, I can't make this stuff up. Okay, let's see. Thank you, Miss Bees, for the super chat. I appreciate that. Look at the woman that gave Nesto $250K. Yeah, that is true, Miss J. We can always say, well, we wouldn't do, but there are people, depending on, different positions in life, what they're going through, what they want to believe. It's some people that are really charmers and they can charm you up out that wallet. Thank you for being a member for 3 months. I appreciate that. Angelique, welcome to the Intellects. Thank you for becoming a member. I appreciate you. Y'all ready for this? Because when he talks about the false statements about his finances, this is very interesting as well. Well, all of it is interesting. But just as the defendant lied to lenders, the Andersons, and Belmonte about his finances, it appears he has also lied to the courts, the probation office, the I, the R, and the S, and the Nassau County Family Courts. Child support. They made it to the memo. The defendant has repeatedly held himself out as a wealthy and successful real estate investor to the public, his community, the Andersons, Belmonte, lenders, the probation office, and the court. The defendant reported that for over the last 20 years, he has worked in real estate, specifically investment properties. Defendant's testimony that he is a real estate investor. He testified that he has 2 accountants, including one who has worked with him for years and who takes care of his finances. Now, all of this information is from the trial transcript. The defendant reported that he received income from speaking engagements as a visiting pastor at other churches prior to his arrest. That's out of the pre-sentencing report. That's what PSR stands for. That comes out from the probation office. The defendant stated in his sentencing submission that his, quote, source of income for close to 20 years was public facing and in investing. I don't know what public facing is, but maybe that was a typo. The defendant stated that he and his church spent $25,000 on school supplies for children in 2023. $20,000 for food for those in need in or about 2022, and donated money to a number of homeless and battered women's shelters. That's in the defendant's memo. That's what he said. He also told the probation office that he has, quote, purchased vehicles for some of his parishioners when they needed assistance. That's what was in the pre-sentencing report. Inconsistent with the above representations about his wealth, the defendant reported bank account balances of $181.54 and $0 to the probation office. In tax years 2017, 2018, and 2019, the defendant reported annual incomes of $5,280, that's 2017, $8,634 in 2018, and $12,260 in 2019. Y'all know 2019 is when he married Asia, right? So you was making $12,260 that you reported to the IRS when you married Asia in that year. I wonder if they probably ain't filed joint though. I don't think they did. To the Nassau County Family Court, he provided an annual salary of $22,880. So he told the friend of the court over there that he only made $22,880 in 2017. That's what he told the people. So that means his child support payment could not have been that high. He reported to the probation office that he was $64,000 behind on his child support payment obligation. So we just want to know when you paid, because if you only was making $22,880 and you $64,000 behind, like, the defendant also has unpaid judgments against him that date back to 2022. I think he got some that's before that, but because he owes that conductor. There was a judgment with the conductor. It was a couple judgments when we first started talking about him. But anyway, the defendant told the probation office that he does not collect income from the church. He reported owning 2 real properties, his residence in New Jersey, and a multi-tenant dwelling in Connecticut. But both of these properties were purchased with fraud proceeds. The defendant declined to provide the probation office with financial information regarding his purported real estate investments. And as discussed below, the information defendant did give to the probation office was internally inconsistent. He provided one set of numbers when interviewed and a different, less favorable set of numbers when supplying a financial affidavit for purposes of probation determination of a recommended fine. The defendant's remands. On or about May 20th, 2024, the defendant was remanded pending sentence pursuant to 18 U.S.C. The defendant's remand was mandatory in part because he was convicted of a crime of violence. We don't need all that. We know about the remand. So basically, here in the discussion, they say a sentence of 151 months imprisonment is necessary in this case in light of the nature, circumstance, and seriousness of the defendant's crimes, the need to promote respect for the law, and afford specific and general deterrence, the defendant's history and characteristics, and the applicable guidelines. The defendant's complaints about the condition of confinement in the MDC are outdated, false, unsourced, or not specific to the defendant. I said that. I was like, how you talking about what happened in the winter and you not even in the wintertime and you only been in there for 2 weeks? What are you talking about? But in any event, are largely irrelevant here as he has been detained only for a matter of weeks and will most likely be designated to a different facility after he is sentenced as set forth below. So they're saying that the guideline range is 151 to 188. So they go through all the guideline calculations on where they got this from. And they go to the different groups. Group 1, Group 2. So let's go on. The defendant abused his position of trust. 3B 1.3 calls for a 2-level enhancement for a defendant who abused a position of public or private trust in manner that significantly facilitate the commission or concealment of the offense. That enhancement applies to Whitehead's crime against Pauline Anderson because the fraud against her was significantly facilitated by the trusted position. Whitehead held as her son's church leader. The defendant was, as the court knows, the pastor who led his own church. The trial record made quite clear that Whitehead's status as a religious leader and as Rasheed Anderson pastor in particular caused Miss Anderson to trust him. And then they quote Miss Anderson, who says, I believed he had integrity. I believed him as the leader of the church. I honestly felt he was trustworthy. I really believed he was a man of God. That's in the transcript. Miss Anderson also says she trusted Whitehead because he was a bishop and because of a relationship with her son. Rasheed Anderson testified that he trusted the defendant because of their really close relationship and spiritual bond. That testimony and other similar testimony at trial readily established that Section 3B1.3 applies. So they're saying there should be a 2-point enhancement. Was it 2 points? Yeah, 2-level enhancement because he has a position of trust. Then they say the probation office correctly calculated the loss amount, which was $7,285,000. If you guys recall, Whitehead is saying because it wasn't really an actual loss, because the Fendura, they never got the money. He wasn't really convicted of any of the, like his house, the apartments, the equity loans. He wasn't charged with that. So he's saying that that shouldn't be a part of it. So it should just be the $90,000 or $85,000 because he did give Miss Anderson $5,000. So it should be the $85,000 of the actual loss suffered by Anderson. That's about what they're saying. So they're going through to say, nope, that $7 million is on point. They're saying the probation office correctly applied the 2-point enhancement for the threats of physical violence to Belmonte. So they said it's another 2 points that should be on there to enhance it. Okay, this is the discussion. Y'all ready? Lamor Whitehead presented himself to the world as a religious leader, a preacher of the prosperity gospel, whom God had made wealthy. He appeared to relish being a public figure, regularly giving press interviews and touting his relationship with various celebrities and public officials. One interview and profile from before this case was filed described Whitehead's bewildering, Waldo-like tendency to show up where you least expected him, flanked by legitimate VIPs. So they have like different stories. They found articles even before he was indicted for these charges. He regularly went out in public in expensive designer clothes, driving a Rolls-Royce SUV. He lived in a mansion and claimed to be a real estate investor, and in fact owned a relatively large apartment building in Connecticut. These trappings of wealth and success, which aided and were a part of the defendant's fraud in this case, were phony. The defendant was living a lie. His extravagant lifestyle was a facade funded by crimes for which he has now been convicted. These were serious crimes that had real consequences. Victims lost real money to Whitehead. He has been sitting on millions of dollars on ill-gotten gains. I like that, ill-gotten gains, including almost $6 million in fraudulent obtained loans and tens of thousands of dollars stolen from Pauline Anderson, none of which he has paid back. And he is utterly remorseless. Indeed, he has repeatedly made efforts unlawfully to avoid responsibility. He made false statements during an investigation for which he was convicted. He brazenly and repeatedly perjured himself on the stand at trial, and he gave substantially inconsistent information to the probation office about his finances in an apparent effort to avoid paying a fine in this case. Given all of this, and for the reasons discussed below, Section 3553 sub A factors support the imposition of the guideline sentence. Contrary to the views of the defense and the probation office, there is no basis for a downward variance. If you guys recall, when we went over Whitehead's pre-sentencing sentencing memorandum, apparently the probation office wanted a downward departure. I don't know why. I must have gave them credit for some things or didn't enhance it or whatever, but they felt like it should have been below the guidelines. So the government is like, nah, the probation officer is wrong and his attorney is wrong. And no. 151 months is sufficient. The nature, circumstances, and seriousness of the offense and the need for just punishment. So it like goes through all of the different prongs on the sentencing guidelines. Okay. 151-month guideline sentence is necessary to reflect the nature and circumstances and seriousness of the offenses and to provide just punishment for them. As an initial matter, each of the defendant's crimes was individually serious. Stealing from a parishioner who entrusted the defendant with a substantial portion of her retirement savings because of his position as a pastor and his close mentoring relationship with her son is serious. Stealing from banks via brazen calculated fraud is serious. Attempting to extort and defraud a businessman, even one who is himself an alleged criminal, is serious. So they said even though Belmonte is currently indicted, even though he is like a criminal himself, we know that allegedly because he ain't convicted yet. Or he may not be convicted. He's innocent right now, but he is indicted right now. They said it's serious. You can't, it don't matter if they allegedly a criminal. You can't extort them neither. And repeatedly lying to federal agents who are investigating these crimes is serious too. Any one of these crimes alone would merit substantial punishment. But Whitehead single-handedly committed all those crimes. That is one particularly striking aspect of his conduct, how wide-ranging it is. Whitehead did not just steal from fellow alleged criminals. He did not just steal from faceless financial institutions. He did not just steal from trusting parishioners. He stole from all of them. He stole constantly, and italicized. And he did it all by himself. Even money he brought in legitimately was in truth a product of his frauds. It is not clear whether Whitehead made any income from his supposed real estate investment business, but to the extent he did, that income was the result of his crimes. He committed fraud to obtain financing to buy real estate investments. Whatever income Whitehead made from his church, leadership, and his congregants, quote, seeds and quote, tithes, was effectively the product of fraud as well. To the extent Whitehead received public attention and had followers, it was because of his flashy, expensive, luxury lifestyle, his mansion, his Rolls Royce, and his expensive suits. All of those things too were funded by his crime. So basically, even your people that follow you on Facebook or Instagram, it's because the facade you put up and you really was broke. And that's what they're saying. You, even the people that follow you ain't even real. People follow you because of your crimes, because they thought that you had the money that you saying that you have. So even that's fake. Your whole life is fake. Everything about you is fake and phony. The duration of Whitehead's crimes also exacerbates their seriousness. These were not isolated incidents. Whitehead engaged on a pattern of criminal conduct spanning years, and he showed no signs of letting up. His attempts to extort and defraud Brandon Belmonte were stymied by the government's involvement, not by anything Whitehead did. It stands to reason that but for the government's intervention, Whitehead would have simply continued to defraud the spared victims indefinitely. So then they get into these. Okay. The financial, emotional, and spiritual harm caused by the defendant's crimes further highlight the seriousness of the offense. And then they have the example, the impact statement by Miss Anderson. Like many other church parishioners who joined a congregation, Rashid Anderson first met the defendant at a time when he was looking for purpose, spiritual guidance, and life advice. His mother, Miss Anderson, first met the defendant after she had survived through pulmonary embolisms that nearly took her life and was seeking spiritual support. Miss Anderson, a full-time nurse, is the primary breadwinner in her three-person household in which she cares for her elderly mother and sick sister. Miss Anderson's serious medical condition led her to consider her own mortality, and she feared that if she was no longer living, her mother and sister would not have a place to live or adequate support. In this context, she gave her hard-earned retirement money, which she has saved over the course of decades, to the defendant. Financially, losing that money has put Miss Anderson in debt and has put her life on hold for several years. As Miss Anderson describes in her victim impact statement, she has been in turmoil since May of 2021, and the defendant's criminal conduct has caused immeasurable pain and stress. Indeed, the harm caused by the defendant's fraud was palpable in the courtroom, which both of the Andersons testified, and underscores the seriousness of the offense. Okay, let's see what we can skip here, because honey, they get into the needs to promote respect for the law and deter crime. So what they're doing is saying why this 151 months is appropriate under the guidelines. First, the defendant's criminal history and his offense conduct point to the need for the substantial sentence the government is requesting in order to deter him from committing future crimes. The defendant has been committing crimes consistently for at least 20 years in order to fund his opulent lifestyle, and he has been completely undeterred by arrests, convictions, and even a lengthy prison term. In 2002, at the age of 23, the defendant stole a Mercedes from a car dealership by lying and using the name Ronald Richardson. See, he don't even want to use his own name. I don't understand why he thinks somebody want to take his identity. He then lied to law enforcement when asked who owned the car and attempted to bribe the arresting officer in exchange for his release. About a year later, in 2004 and 2005, the defendant committed a sprawling fraud by using numerous stolen identities in order to obtain car loans and to other purchases. The defendant was arrested in 2006, at which time he was driving a Range Rover that he had purchased using a fraudulently obtained loan. The defendant was sentenced initially to 1 to 3 years imprisonment for numerous counts of identity theft and 16 months to 4 years imprisonment for grand larceny and fraud. He was sentenced to 1 year of imprisonment for criminal possession of the Range Rover. The defendant served a lengthy incarceratory term and was released from prison on parole in 2013 when he was 34, at which time he established his church, Leaders of Tomorrow International Ministries, a role he prepared for while incarcerated. In 2017, the defendant was discharged from parole at the age of 38. A year later, in 2018 and through 22, the defendant began his scheme to defraud lenders, specifically Fundora and PayPal in 2018, Homebridge Financial Services in 2019, Bethpage Federal Credit Union in 2021, FM Home Loan in 2021, Connect One Bank in 21, and Sunset Equity in 2022. If you read the footnote, though, that talking about the case, it has the defendant maintains that he was also wrongfully convicted in connection with his large-scale car loan fraud and that he would have been fully exonerated. That is what was said in the memo. Apart from his self-serving conclusion, however, the defendant offers no proof that his conviction should or could have been overturned. The defendant also notes that his conviction was quite remote in time, but fails to address the fact that soon after he was discharged from parole, he began reoffending. He just got off of parole in 2017, and it's the first thing. In 2020 and 2021, the defendant defrauded Miss Anderson. In 22, the defendant attempted to extort and defraud Mr. Belmonte. In 22, the defendant lied to the FBI. In 24, the defendant lied under oath at trial to the jury and to the court. In light of this history, Whitehead presents a substantial recidivism risk. I would have to, particularly given that his life appears to have been funded by fraud, and it is not clear that he will have a source of legitimate future income. There is a significant need for specific deterrence here, and a sentence longer than the subsequently reduced 8-year state sentence he previously received is necessary to achieve the deterrence that Whitehead's prior conviction and sentences have not achieved. Second, the defendant's complete lack of remorse for his crime shows that the court sentence must promote respect for the law. And then it has all the case law. The defendant has, as noted by the probation office, quote, not taken responsibility or shown remorse for this action, end quote. And his sentencing submission fails to address the nature, circumstances, and seriousness of his many crimes. In fact, not only has Whitehead expressed no concern for his victims, he views himself as the victim in this case. That has been true since he was charged. In March 2023, Whitehead gave an interview in which he dismissed this case as an attack on a black man and a political attack in which he was collateral damage. Even after his conviction, he continued to promote the narrative that it was this case and not Whitehead himself. That was wrong. He went on to a press tour following his conviction in which he decried his purported mistreatment at the hands of the FBI, the prosecution, and the court. In Whitehead's own mind, this case is the fault of everyone but himself. And there is no indication he cares about any of his victims or any of the millions of dollars he has stolen at all. Perhaps that should not come as a surprise. It is of a piece with how Whitehead has responded to every other setback in his life. It was evident from the lengthy text message exchanges between Whitehead and Eric Adams shown at trial. Adam recognized astutely that Whitehead constantly blames everyone but himself for his problems. That is also how Whitehead has responded to prior interactions with criminal authorities. After the prior fraud case in which Whitehead did prison time after losing at trial, Whitehead tried the same approach he has employed here. He claimed that he was framed because the cop couldn't get him to cooperate with him and turn on his friend. Whitehead did the same thing in connection with 2018 harassment charges in a case in which he allegedly, quote, put his hands around the neck of his ex-wife and applied pressure. What? And, quote, he also put his hands around his son's neck and applied pressure. Whitehead dismisses that case too as an example of how his ex-wife, quote, tried to destroy him and filed a false child abuse case against him. What? Bishop B said, I knew it. What? I clearly didn't read that. I was glancing over it yesterday, so this is literally the first time I saw this. Well, there you have it. Some people were asking that question if he, had any abuse charges. Well, apparently, according to the pre-sentencing record, he does. It says Whitehead dismisses that case too as an example of how his ex-wife tried to destroy him and file false child abuse cases against him. This complete inability to take responsibility and utter lack of remorse should concern the court. The fact that it is a pattern, the fact that the defendant has repeatedly committed serious crimes and repeatedly cast the blame for them on everyone but him makes clear the risk that he will commit other crimes. Let's revisit something real quick. So I have the sentencing, as you guys see, where his name was Lamar. This sentencing transcript, it was very, very interesting because I'm going to go to what the prosecutor said in this case. Okay. And then we'll go. Whitehead had a lengthy response as well. He did talk. So if you guys want to get a preview of how he'll probably be talking on Monday and what he'll say. But let me see. So this Mr. Pearl was the prosecutor on this case. So let's do this transcript right quick. Your Honor, I sat through the, I guess, approximately 9-week trial. So this trial was 9 weeks. You heard every victim that marched through this courtroom and testified about how each had to endure having their credit affected. This defendant victimized over a dozen Suffolk County victims. He also victimized people from the state of Tennessee and the state of Florida, and they got the names from Florida. In the course of these thefts, it's the people's position that the defendant obtained $134,000 of cash or automobiles, and he approached $1 million in theft. I did specifically remind the court one person who wasn't able to be here. Okay, there was somebody from Tennessee not able to come. She testified at trial. She told us countless times it took her over 2.5 years to be able to get any credit after this defendant victimized her. And I remember another lady. Personal information was found in the jacket, in the sleeve, her date of birth, social security number, and her name. You had another person who's still having trouble getting cars from creditors because of the Land Rover this defendant tried to steal. Your Honor, this defendant in a systematic way went around and destroyed good names and reputations of all these victims. The court had the opportunity to see through the course of the numerous conferences in the 9-week trial how this defendant displayed a level of, for lack of a better term, hubris and greedy. I suggest rarely seen in this courthouse. This defendant used everything and anything to avoid responsibility, including not taking any responsibility for this action in the PSI. That's the pre-sentencing investigation. Same report they PSR in federal court. And I venture to guess he won't take any responsibility for it today. He doesn't deserve any mercy from this court. This defendant went so far as to use his own child as an excuse to get mercy from this court. Ain't that what he did when he wrote the letter and said that his baby needs him? And at this point, dressed as a priest and came into the courtroom and cited scripture to this court. Along those lines, Your Honor, when the people do recommend state incarceration, I hope the court does sentence the defendant to state incarceration. There is a scripture that this defendant should be mindful of from the book of Proverbs. And this quote, a good name is to be more desired than great wealth. Favor is better than silver and gold. That is something that the defendant could spend his time when he's doing his state time thinking about. Accordingly, Your Honor, the people are making the following recommendation. Count one, we recommend 2 to 7. Count two, 7 years. So they go through all the counts what they recommended for a total of 14 years to 42 years. That's what them prosecutors was asking for. I do understand, Your Honor, that pursuant to Penal Code Section 730, that it may be modified to the sentence to read as an indeterminate of 10 to 20. However, the people are still recommending their sentence of 14 to 42 years. Your Honor, as to each and every other conviction, and I'm not going to go through each one, we'd ask the court to sentence the defendant to the maximum state prison to run concurrent with that 14 to 42 year. Thank you very much. Then you got Whitehead who comes up. Let's talk about him for a minute. And this thing, that's why I said this stuff is so similar, it's almost scary. And you did like 6.5, 7 years, and you come out and you have the same accusations and convictions. That is crazy. But he gets up and says, first and foremost, I just want to thank God for allowing me to wake up to see the day. Now, this was back in 2008. Okay. Second, I want to thank my family for supporting me. And this had been a rough time for me and my family. This district attorney sits here as an officer of the court, portrays to be a perfect officer of the court, which he is not. They put my family and myself through so much trials and tribulations beyond your wildest imagination. They've had friends from New York City arrest me. They took me out in the rain, carrying my bag, shackled up. Everything that this district attorney had to do, he deceived the court. If the victims was here during this trial, they would have no hatred for me whatsoever. If the victims was able to see the things they covered up, they would have no hatred for me. So now they covered up stuff. And if the victims knew what they covered up, they wouldn't not like you for taking their identity and jacking up their credit. Mr. Keon is a phenomenal attorney. He's a blessed man of God because he didn't have to treat me the way he treated me. I've been through 3 attorneys prior to Mr. Keon that all ripped me off, first and foremost. And then he go through the name. So they have misled attorneys. The same letter they said that the same letter they wrote said they have no voice recordings. They played those same voice recordings in August of 2005. That's all the DA did, kept misleading. And I just want to thank you also for being the judge that you are, because you respected me as a man. You looked at my character. You've been a judge for quite some time. You've been different. You've seen different types of people come in front of you. And Your Honor, I don't have to do nothing illegal. I have a family. I'm married. Tomorrow is my 1st year anniversary. Can you imagine being married to this guy and then within your 1st year, he end up getting arrested and go to jail, prison for a while? I spent my birthday in here. I'm a family man. I have my son. I would never put my son on the line. Never. And here we are. Here we are. Now, your baby was just born the first time. And now this the same baby or son who is 16 and had to write a letter yet again because of what you were just convicted of. Here we go. My father was killed when I was 2 months old by police officers, white police officers. But do I hate white people? No. In the Bible, since you want to get biblical, it says you can defile a man with words, but what not goes into his mouth, but what comes out of his mouth that comes from his heart. That's how to defile a man's spirit from his heart. You look at a man's spirit. These people put me through pain, man, pain beyond pain, and left my wife out here with nobody. What? I didn't know I was going to get remanded. I didn't know that. Does that sound familiar? I had business ventures that I worked. I've been in front of your court 2.5 years, never missed a court date. I respected you. That's another thing of why they felt that was the exact same argument his attorney gave as to why he should not be remanded, because he came to every court date and he never missed any hearings that the judge had him come to. And Your Honor, you said, Mr. Whitehead, I promise you'll have a fair trial. And that's all they did, man, was play under the table and deceive, man, make everything look right. It wasn't that. That Detective Gabriel, man, he tormented me, my family, tormented my business while I was trying to make money to pay for an attorney. He called my office, threatened my employees. You want to talk about credit? My credit is shot. I lost my house because I've been incarcerated. So because you got remanded until sentencing, after you got convicted, he got remanded in state court, I think. You saying it's everybody's fault because you lost your house again. See, he said, I lost my house because I'm incarcerated. On May 31st of this year, he lost his house too. And for you to say that I can't come in here and walk as a priest, listen, I fear God. I don't fear you. I don't fear the district attorney. I fear God. For me to come here as imposter, you have no respect. There's no way I could respect you more than God, just to impose as something I don't impose. And if you want to get back to scripture, 105.15 says, touch not my anointing and do my prophet no harm. So he's been using this scripture for a long time. And if you want the scripture, look at the judge and ask Judge Hudson. This is why Judges was profound to the judges. And chapter 2:16, it says that God was with the judges because Israel was being taken over by the Babylonians. And so God loved Israel. And he didn't want to see Israel die too. Huh? So this is what brought forth judges, so Israel would not spoil. So the judges could judge the enemy to save the righteous and look at their heart and understand, I love God. And you quote me scripture about there's a season. There's a season for mercy and a season for leniency and a season to see my spirit and understand that my son and my wife don't deserve it, man. This is 2008. I wasn't accused or convicted of hurting nobody. And these numbers, that's like killing somebody. Come on, man. You look at my record, man. Look at my record, man. I help young people. This 2008. He helped people. Y'all see this? I helped the church. This was 2008 on his way to prison. I don't have to sit here and say lie to nobody. I don't need no leniency from Mr. Pearl. All I need is leniency from God and Jesus Christ, man. Ain't that what all his posts are? Only God can judge me. I'm just different. I do what God tell me. And yes, I am an ordained minister. And yes, I preach. Yes, I preach the gospel. So he alleged he was already an ordained minister before he took his hind end to prison the first time. Judge Hudson, man, like I told my wife as she cried to me on the phone from time to time that she's struggling. I said, you got to be strong. I said, and I call her baby. I said, baby, I drink juice out of a lotion bottle. They have done me wrong. And then the audience memory was like, oh God, like, come on, bro. The defendant, they have done me wrong, Judge Hudson. Don't that sound like what they're saying about the his why he's being held at the holding facility until he's sentenced? Not to mention, through my investigation, Macedonia was friends with Detective Gabriel. Now he going against disparaging the detectives that's on the case. He used to go to high school with him. They done me wrong, man. When they took me in the alleyway, they took him to the alleyway on this one. When I came to you and told you they took me in the alleyway, you said my attorney will handle it. Now remember, on this case that's pending, he said the detectives said they was going to slam him and they was going to bend his fingers back. On this one, they took him in the alleyway. Macedonia ain't do nothing. Then his attorney said something, Mr. Keon. He talking about this is new. The attorney says, this is new to me, Your Honor, man. Don't take me from, whatever. Okay. They must have been talking at the same time. Let me see. Okay, he said, this is new to me, Your Honor, man. Don't take me from my son. My sons need me. I'm not using my son as leverage, but my father was taken from me. Isn't that not what he is saying in his sentencing memo? Is this not what his same argument is? This is 2008. We are in 2024. 15 years later, and he got the same song and dance. You think and I know this is going to get overturned. Ain't that what he said? That this case was going to be overturned? Huh? Mr. Keon had to do what he didn't do for me, Your Honor. I was scared. Didn't trust nobody. I was scared. And you want to know what? That's why every time I come to court, they want to remand me. And you said from out your mouth, bail is not punishment. It's surety that he comes back. I never disobeyed the court. Same exact argument. And Mr. Keon will call me times a night just to talk to me and ask me different things. Your Honor, man, my first year anniversary is tomorrow, man. I'm in New York Theological Seminary, which is a ministerial school that I was president of my class. And I couldn't finish my other semester because I was remanded. So that's the court's fault that you got in trouble? And so you got remanded? I deal with the district attorney's office in Brooklyn helping kids, starting a program while this was going on. Y'all see this? Cookies, giving out food, doing stuff. It's almost like you do a lot of this stuff so you can say you did it to hope that somebody give you leniency when you say that you did it. Your Honor, I don't have to lie to you. The other thing is another thing. When you read the Bible, it shows you can't change character. You can't change spirit. You could fool somebody for a little while, but you can't change it. The real them will come out. You seen me 2.5 years. And 1 Corinthians 11:13 and 13 and 11, it says, quote, when I was a child, I thought as a child, I understood as a child, but now with God, I'm a man. Since you want to get biblical, Mr. Pearl, he coming at the prosecutor for quoting that scripture. And it says that in Psalm 23, though I walk through the valley of the shadow of death, I'll not walk through to death because God is with me, end quote. This is just a shadow because this will be overturned. And the things that I seen Mr. Keon pick up, he didn't have to do that. He didn't have to do what he did. He's talking about his attorney. This is the third attorney that I guess he liked. And I just asked you to just consider, Your Honor, when you said that there's a season for trial, I went out there and tried to find a lawyer. I found him 2 days and I met him. I met him 2 days before my trial. I drove out here to meet with him. And I established my character with him. I established who I was with him. He would have never took this case, not before no money. He would have never took this case. And he complimented me throughout the trial. He said, Lamar, you're a good client. He said, you fight them, Lamar. That's what I'm about, Mr. Judge Hudson. I got to fight for my freedom. They did my family wrong, man. They made this whole case, my life, a whole debacle, man. I didn't know which way was up or down. I could remember I called your office. I was afraid. I was afraid I'm just going to be honest. I was afraid they had your ear. I was afraid the things they were doing to me that you don't know about. It will take me all day to explain, but they know and he knows it was personal vendetta. It's not about you could put aside. I'm just talking about my character. You could put aside the guilty or not guilty, put aside, but fighting fair. They didn't fight fair. That's why he has a smile on his face. So apparently, no, I'm telling you, based on what you're saying, that prosecutor was over there trying not to laugh and disrespect the court. He's probably over there like, this clown, what is he even talking about? What is he even talking about right now? This fool over there talking mad. What? Huh? Touch not my anointed. Yeah, all right. I'm telling you. Mr. Pearl, man, let me tell you something, man. I just want to say one thing to you. That I'm still going to be a man of God no matter what you say, man. No matter what you do, I'm still going to love my Jesus because he died for me. He didn't have to die, but he died for me. And I don't have to perform for you. For what? You have no judge over me. I don't have to perform for you. You know in your heart, you deceive. You did everything possible. Every witness that you put up there to talk against me, Mr. Keon caught them in numerous lies and they had agreements. Your Honor, all I want is a chance. My son's first birthday is coming up and I want to be there. This the same son. Now I got to write the judge to try to say, I'm going to need my daddy to be out. And he's 16 now. My father wasn't there for mine. And then he says 14 to 42 years. Who did I kill? I read in the paper, I've been studying. Men stole $450 billion getting 14 to 20 years. A man stole $200 million getting 6 years. And he says 14 to 42 years? People killing people getting 2 to 4. And he says 14 to 42? Your Honor, all you did was respect me every time I came in this court. I was a little frightened once you remanded me, but I got closer to God. I got closer to my wife. I got closer to my family. I got closer to them. I understood who have my back and who don't. There's a season for time where you got to see who have your back. My lawyer had my back. I keep saying that because you don't understand how I've been ripped off. He had my back. He gave me time to talk. He talked to me. Nobody want to talk to me. I didn't understand this. Manhattan trial was atrocious. It went a day and a half, almost 2 days. It was atrocious. I didn't know which way was up. And this is what they did to me. And I paid the price. And these victims says that it took them years. A lot of my business partners Google my name. My business, a lot of business down the drain. No trust. District attorney stole my identity. I went through pain, Your Honor. Y'all see how he the victim in this? Just like they say, he act like he the victim in this other case. I don't know if you already have a sentence already written down. He did. Or if this made any sense. It didn't. But I sat here and watched you 2.5 years give mercy to people and give leniency to people. And I seen you sentence a lot of people and seen their families cry. And I seen it. And I asked, actually, Your Honor, when you sentenced one of the boys, a boy killed someone. I'm going briefly. His family was out there. They went out and they were all discombobulated and they had a press circle with them. And I prayed with them because they needed strength. That's when I had my collar on. I prayed with them because they needed strength. And do you know, Your Honor, I had so much to think about when I was in jail. You have a nickname in there. That's scary. They call you Hang 'em High Hudson. He told the judge in jail, they call him Hang 'em High Hudson. So then the court said it's more because of the H with the H anyway with the names. Then he goes on, Lamar says, Lamar, he was Lamar then. So this is Lamar. This ain't Lamar. This is Lamar. They said you sentence hard. That's what they say. And this is torment. And when this district attorney calls my attorney, the district attorney calls my attorney to show, they know they're going to lose to say they want to talk out something. They want me to admit they would give me a lesser sentence. Yes, that's why they kept postponing to give me a lesser sentence. So then that I won't appeal. His attorney keeps trying to interject. Well, judge, let me clear up the record in that regard. I had a conversation with the district attorney's office, and I know that the court on occasion will sentence more leniency if the individual accepts responsibility at the time of sentencing. So I had a number of conversations with Mr. Pearl and with Jody concerning where they would be at in recommendations, depending on what might be said by my client. I passed that along to my client. I had a number of conversations with so he's saying stuff where now his attorney got to explain. Court like, thank you. He said, and his attorney said, I thought it was imperative to put that on the record. So then Lamar goes on. Your Honor, I'm pretty much done. You got more? So that's why DA Pearl was over there like, I just asked you for leniency, Your Honor. And just, Your Honor, you look at me, man. You see me from a boy turn into a man. Jail is not going to do anything for me. Nothing. I'm already intelligent. I'm already helping people. I'm already walking the walk of God. I'm doing the right thing. I haven't been in trouble until the detective calls his friends and arrests me. And then they dismiss the charges. But I haven't been in trouble, Your Honor. I haven't done anything wrong, Your Honor. Jail is not going to do anything for me. Nothing. If you give me 1,000 or 2,000 hours of community service, I will serve that to serve and help people. He asked for community service. Use me to change a lot of them brothers in there. They're lies, man. He said, I have prayed every night. Every single night. I have had Bible study. And every Sunday I preach to them about God. Use me to change a lot of them brothers. They're lies, man. People that got sentenced to 25 years to life. Okay, well, he could have used you in jail again. I mean, you could have had a prison ministry. Your Honor, jail is not going to do anything, Your Honor. All it's going to do is hurt my family and hurt my wife. She's struggling. Hurt my son. It's rough growing up without a father. It's rough, Your Honor, especially to be my race. It's rough. And I'm not asking for I'm not playing no pity party. You're not? If I was a judge, I probably would have been like, I'm talking from the heart, Your Honor, the heart. That's all. I'm finished talking about it, Your Honor. Then he goes on, Your Honor, I know God. He said, I'm finished talking about it, Your Honor, as he proceeds. Your Honor, I know God is with me. And I just want to say this last thing. This the last to the last to the last. When I was going through this trial and Mr. John Whitehead got sentenced, I was out there. I heard a lot of court officials say she's going to feel a lot of heat behind this. And I heard a lot of people say that she is not running and that she has nothing to worry about. It was a political. They was thinking more political and not thinking about a person's life. Huh? Political for this? Just like it's political for this. Is this not a copy and paste? And I ask you, Your Honor, please, about my life. Please, please think about my life. I'm more of an asset to people on the outside than to be on the inside. You see what happened when he was on the outside? Miss Pauline lost $90,000. Well, $85,000. The financial institutions, they got duped out of a few dollars. And I mean, they got some buildings they can sell. I mean, me and my wife made vows yesterday. Tomorrow it will be a year. We haven't been able to enjoy our wedding. I mean, our marriage whatsoever. So my question is, if this is a year later, assuming you go through a process, like either you got married while he was going through this process, or you got married and then immediately he started going through this process, like within weeks or something. Because a year by the time you're sentenced, you spend your first wedding anniversary in the penitentiary. And I ask you, Your Honor, think about my life, please. Please think about my life. I'm more of an asset to people on the outside than on the inside. Me and my wife made vows yesterday. Tomorrow will be a year. We haven't been able to enjoy our wedding. I mean, our marriage whatsoever. I just asked for the chance, Your Honor. You could sentence me now. You go home to your family and everybody go home with their family. So you're going to try to guilt him into not letting you, to not putting you in prison? But for 8 weeks, 8.5 weeks, I drove from the city an hour and a half back and forth, back and forth. Even my mother got sick because we used to sit in the car. It was cold. She got sick. She couldn't come the last week because she was sick. I was obedient to the court, Your Honor. I thank you for the opportunity to express my gratitude. And I just hope you understand how much I appreciate you for being the judge that you are. I'm not looking for no pity party, as the DA says. And I'm just telling you from my heart, Your Honor. If I lied to you, may God strike me down right now. It would have been crazy. I'm like, lightning would have surged through the window. I am a man of God, and I will walk with God, just like he walked with me. And I will be consistent with him, and I will have faith all the way, Your Honor. And I thank you for this opportunity, for giving me this opportunity to tell you, because I couldn't speak a lot of the times. It was just, we got new court date. I never knew what was going on. I never knew what was going on. So I thank you, Your Honor. And I want to once again thank my counsel for the 50th time, Mr. Kenyon, for his hard work, man, and his honesty to me, man. That's all I wanted was honesty. And if I had him in this beginning, I probably couldn't be here. And I want to thank my family for their prayers and their support and their love. Your Honor, man, thank you. So that is what he has said for the first trial that he had, and conviction and all of that good stuff. WC Field says there's a sucker born every minute. Thank you, Happy Days Coming, for the super chat. Cupcake said he stole somebody's whole daddy. Where's Lolisa? Lolisa. Falana, thank you for becoming a member. Mom's the Boss said, thanks, Pam. The member link helped me to find a... Okay. You're welcome. Doretha, she gifted 10 memberships. Welcome to all of the 10 new members over here. We appreciate you. We really, really do. Welcome to the Intellects. He said a whole lot of nothing, but never apologize to the victims. Thank you, Doretha, for the super chat. Cheryl Hill, thank you for the super sticker. Sad using his dead father, kids, and wife to escape Jesto. And that's those twins. Thank you again, Doretha, for the super chat. I appreciate that. Do y'all want to hear what this judge had to say? Hey, Lisa. He was talking about your daddy back in 2008 to try to get up out of his first issues. It was political. Got it. You said all of that. That's what you got out of all that reading I did. You seen all of that reading that I did, and that's what you got. All right, we ready for the court. I know we came to watch this, but when I was reading the parts that I read of the sentencing memo, I was like, why does this sound so familiar? And then I was like, let me pull up this transcript, because I talked about this it's probably been at least a year and a half when I went over this. So a lot of you guys probably weren't even over here subscribed. Do me a favor and hit that like button. I hope you guys are enjoying this commentary right now. But let's get back into it. Let me see. The court said, you're welcome. Mr. Whitehead, when you came before this court, you were released. You came back every occasion. You referred to the way you were treated by this court. The court viewed you as an innocent man at that time until that one moment. This is when you talk about judges before, you forgot about the 12 other ones. You have one judge of the law, and you, according to best of my ability, I attempted to make sure that you received all of your legal and constitutional rights. And that is for a higher and wiser court to determine whether or not my decisions were in error or not. And as always, I accept their decision, their determination, and their direction. But you had 12 sworn jurors, 12 sworn judges of the facts, strangers to you, that heard all the evidence in this case and unanimously found that you had committed these crimes. You could declare your innocence, that is your right. But then, in the same token, repentance does earn a reward when it is sincere. Initially, the court imposes upon you, as part of your sentence, a mandatory state surcharge in the amount of $320. Then the clerk said there's restitution. Okay. The court is also granting the people's application for a permanent order of protection against you. So then it had all the names of the people that he got protection orders against. So then he goes in. If you violate the terms of that order, protection charges could be filed against you, which, depending upon the manner in which they are violated, if they result in serious physical injury to a beneficiary, you could receive up to 7 years in state prison for aggravated criminal contempt. Initially, I would like to commend the attorneys in this case. Mr. Keon, in spite of overwhelming proof presented by the people, you represented your client zealously. Basically, I already know the facts. You can't create the facts, but you did the best you could. Like, you did the best you could, Mr. Keon. You represented your client zealously and with dignity, in the best tradition of the defense bar. And it was truly an honor to have you before this court. And for that, I thank you. And for DA Mr. Pearl, Miss Francis, I wish to convey the court's praise for the thoroughness and skill with which the prosecution presented their evidence and legal argument. In particular, the court wishes to note that during this trial, Mr. Pearl's defense counsel's request undertook an investigation to obtain what could possibly be exculpatory evidence relating to a computer. Such an active attempt to pursue what could be exonerated proof amply demonstrates that despite your vigorous accuracy, you never lost sight of your obligation not to obtain a conviction, but to see that justice be done. You have the court's thanks. So apparently there must have been some allegation that there was a computer that may have exonerated him. And this prosecutor said, well, let me check into that. If you have exculpatory, aka favorable evidence for Mr. Whitehead, let's look into it. But clearly it probably didn't come out to be nothing. But regardless, you did not say, I just want to beat him. You said, I want to seek justice. So the court thanks him. Now he gets to Mr. Whitehead. For you, Mr. Whitehead, I could have no thanks or praise. Despite your vehement protestation of innocence, the jury has decided otherwise, and they have defined reality as far as I'm concerned. At this time, my concern is exclusively towards your victims, those decent people whose names that you stole so you could have a lifestyle that they couldn't afford and you didn't deserve. Where the mitigating factors that could justify a merciful sentence, I assure you, Mr. Whitehead, I have looked for them. I have sifted for them. I do so in every case before. Searched all over. Couldn't find nobody. Searched high and low. Still couldn't find no evidence. Say, I sift through everything, trying to find something to mitigate and be merciful upon you. You have a mother who sent me a letter who loves you very much. She sent it in this case too, Judge Hudson. You have a wife who has stood by you. Well, that wasn't the case in this. That's probably the only difference in this case, because we ain't seen Asia. She doing her breakfast of champions, and that's just that. And a young son who needs his father. That's the same son that wrote the letter. So that's kind of similar. Now he can talk for himself now. And it does weigh on me. I know that in sentencing you, I sentenced them. They did no wrong, nothing wrong at all. But your victims also have families whose lives that you disrupted. And I look very closely at that pre-sentencing report for any sign of remorse. I look very closely at you now as you spoke. I noted that as you spoke, I looked at you. You didn't look away. I was looking for something. Remorse, repentance, taking responsibility, something that would show that you understood the enormity of what you did. But you consider yourself to be a victim. What? Ain't that what they just said in this report? But you consider yourself to be a victim. That is wrong. In light of what the jury has said, that is wrong. I don't need a pre-sentence report to tell me everything about you because you forget something, Mr. Whitehead, that I watched you the entire trial as well. The only emotion that I ever saw you display was anger. Various witnesses testified shame and remorse and repentance. That would be appropriate under the circumstances and perhaps would move this court to mercy. Were and continue to be conspicuously absent. The court is left with the question of how to punish this behavior, how to address it. Such crimes, there's been new law enacted in 2002. Your victims have all suffered. The court from the probation report demonstrates you have changed their lives, credit ratings, and reduced business practices. Change due to the fear that you put them in. Your lack of remorse, though, shows that you are more than capable of resuming the scheme once you return to society. Judge Hudson is a prophet. He is a prophet of God and he's accurate. That's who y'all need to be sowing your seeds into, Judge Hudson, because Judge Hudson said you are more than capable of resuming the scheme once you return to society. This is accurate. Preventing this from occurring while you're incarcerated. I have been informed that the New York State Department of Correction will prevent you from having a computer access while in their care. So, Lamor Whitehead, it is the sentence of this court that you be taken from this place and turned over to the custody of the New York State Department of Correction. And while in their charge and care, you'll serve the following period of incarceration. For count one of the indictment, scheme to defraud in the first degree, an indeterminate period of incarceration of not less than 1 1/3 to no more than 4 years in state prison. So they go through all the different counts. Okay, let's go. We'll go past that and get to the end because it was a lot of counts now. Let's see. These count are charges relating to the names. Okay, got the names of the people. The court is mindful of the guidance provided by the appeals courts, which warn against such remedy which may be violative to the Eighth Amendment. Defense counsel has pointed out these were nonviolent crimes. I thank him for that advice. I'm aware of the sentence handed down to violent offenders. Some allowance must be made. I say this to you, Mr. Whitehead. You fired no pistol. You furnished no blade. You drew no blood. You are probably one of the most dangerous men ever to walk into my courtroom. You are a new type of criminal, the internet predator. I find your potential to be as frightening as the internet is promising. Let's reflect for a moment on the effect you had on the lives of some of your victims, as the people eloquently detailed resulting from your crimes as far as their lost credit. Some people aren't using the internet. Miss Spurl, she and her husband are no longer applying for instant credit. Mr. Watchnick said he worked very hard since he came to this country in hopes of having a better life. His credit score is not the same. He is afraid to open his mail thinking that you have given this information to someone else. Mr. Lawler recalled missing time at work. He had to change all his credit cards because of what you did. All of this leads me to say you must be stopped. And all who will follow your example. Just as importantly, your victim should see that the person who stole their most precious possession of all, since it's a day for quotation, I won't quote scripture to you because you are a better authority. But Shakespeare said, quote, good name in men and women, dear my Lord, is the immediate jewel of their souls. He who steals my purse steals nothing. 'Tis trash and has been slave to thousands. But he who robs me of my good name steals from me that which not enriches him, but it leaves me poor indeed. End quote. Accordingly, your sentence shall run consecutively in part based upon the number of victims. So it goes through that. All the counts again. He quoted. So they said for a total of not less than 10, no more than 30 years in state prison. Pursuant to the Penal Law, Section 7.3, this sentence shall be deemed to be indeterminate terms of 10 to 20 years. At this time, I wish to advise you have a right to appeal this sentence imposed upon you by filing a notice of appeal with the clerk of the court within 30 days from today's date. A similar notice must be served upon the DA. If you cannot afford an attorney, you may take application to have an attorney assigned to you without charge. Although discussed at length, Mr. Keon, for the record, at your convenience, would you be so kind as to advise your client of his rights to appeal in writing? Mr. Keon said, I will, Judge. He'll be filing. So he said he was going to file a notice of appeal. The court said, excuse me, the order of protection expiration date in light of the court sentence will be June 30th, 2030. This man is still under an order of protection from the first case. From June, it does not expire till June 30th, 2036. He has 12 years still left on the order of protection in place against those other people. Ain't that crazy? I have some people donating on the way, and I appreciate every single donation. You said JMM55, who's been a member for 1 month, said Nasty Nestle going to get that same lecture. You know what? Dorothea said it's civil. He got the scam coaches. I need y'all to stop. Thank you guys so much for all of these super chats. I appreciate that. Let me see. So now back to the business at hand. I just wanted you guys to see the similarities. I was just, oh, that's her thing from Miss let me see. I keep pulling up the same thing. Oh man, sorry. Here we go. On the stand, the defendant lied just as readily as he had to his victims. Some of those lies were, while important, not centrally relevant to the case. For instance, the defendant testified repeatedly that his accountant filed his tax returns for him on his behalf. He insisted on it. He claimed, for instance, that he did not know whether he earned $0 or $1 million in tax year 2019 because his taxes were never filed. And in any event, my accountant filed my taxes. In fact, Whitehead claimed that he did not file taxes for tax year 2017 through 2022 because he was, quote, a victim of identity theft and cannot file. That was all false. The defendant filed tax returns for tax years 2017, 18, and 19. The defendant signed them. He did not use an accountant. There's no paid preparer on any of them. They were filed in paper using envelopes with the defendant's own return address on them. And then it has a footnote. The government received copies of the tax returns pursuant to a tax order after the trial had ended and produced them to the defense. The government can provide them to the court upon request. Some of the defendant's lies were more central to the case. He asserted that he had never had any conversations with Miss Anderson about the money, but Miss Anderson and Mr. Anderson's attorney and phone records proved otherwise. As he testified that he did not submit the fraudulent loan apps, send or receive emails about them, or doctor any bank statements. The jury saw those for the lies that they were and convicted Whitehead for the exact conduct he had falsely denied. The defendant's right to defend himself does not extend to a right to commit new crimes to try to obstruct the case against him. This perjury, which is noted above, is completely unaccounted for by the guideline, deserves serious sanctions. So they said his lying deserves even more than what he got. Through his sentence, the court has the opportunity to send a message to the victims and to the community about the seriousness of the defendant's crimes and the consequences for committing crimes and engaging in a life of fraud. Importantly, the court has the ability to recognize the harm caused by the defendant and to deter other members of the community from emulating the defendant and committing similar crimes by imposing significant sentence. Now let's get into the history and the characteristics of the defendant. This is what a lot of people talked about, like how these people sending these letters. So that has to be acknowledged. Like many defendants, Whitehead touts his purported good deeds in the support of his community, including by submitting letters of support that describe the defendant as, quote, good works, integrity, trustworthiness, and character. The letters of support describe the defendant's criminal conduct as inconsistent with his character. Well, I just read a whole sentencing transcript from his other trial. This sounds real consistent to me. Then in the footnote, the government says the government notes that it cannot confirm the veracity of Whitehead's statements about his background, his purported good deeds, or the extent of his actual involvement in these deeds. The defendant has significantly inflated his community service in the past, and there are certain aspects of his personal history that have been publicly questioned for their accuracy. The letters of support describe the defendant's criminal conduct as inconsistent with his character, a misunderstanding, or an aberration. That's a recurrent argument in sentencing in cases involving white-collar crimes. As Judge Marrero once astutely observed, so I want you guys to hear this. This is a judge who has analyzed, I guess, when it comes to these white-collar crimes. The defendant's sentencing argument falls into a pattern advanced by a subset of the white-collar criminal. This category encompasses a select class, distinguished, reputable, highly esteemed model citizens such as the defendant. The list of their achievement and virtues is long and impressive. This is a whole nother case. This ain't him. This is another judge who talked about a defendant in a white-collar crime in front of him. At home, they are good family men and women, caring spouses, loving parents, loyal and reliable to friends. At work, they are looked up to as outstanding professionals and business partners. I don't think anybody has really said that about him, though. To their communities, charities, and public causes, they are generous patrons and sponsors. And as worshipers, they are devout, often rising as leaders of the congregation. Okay, Judge Marrero. Yet, for all of their outward rectitude, these otherwise good people suffer a fatal flaw. They sometimes lead double lives. Somewhere at the core, in a distorted dimension of the soul, the public image they present is as false as the lies they tell to sustain the appearance of an exemplary life. And somehow, for reasons that always defy reason, they fall into crime, doing wrongful deeds that seem aberrational, selfish, and greedy acts that when caught, they claim are entirely out of character with their otherwise law-abiding lives. I don't know, Judge, if this applies to him, but I get what you're saying. And then they quote the case where this came from. Whitehead led this same double life. The persona and reputation he carefully crafted, including through his church leadership, was a key facilitator of his crimes. His fancy clothing and cars, his mansion, his church, his sermons, these were all tools of the trade. Whitehead's apparent wealth and success built credibility with lenders and businessmen and helped him to gain the trust and respect of parishioners and members of the community so that he could exploit and defraud them. Indeed, the court saw the defendant's two sides during trial. His loving support of Rashid Anderson for months up until he obtained Pauline Anderson's money, and his scathing text messages to the Andersons when asked to return the money. His initial text message to Miss Anderson that appeared to be respectful, and his later explosive and threatening messages, his attempted extortion of Belmonte and threats to harm him, and his later amicable conversations with Belmonte. The court also saw the defendant's two sides as he took the stand. He was calm and charismatic on direct examination, but aggressive and angry, shouting and obfuscating. I always have a hard time obfuscating during cross-examination. Given these two sides and his double life, it is no surprise that Whitehead still has followers who will tout his good qualities. Having seen how he presented himself to his victims and to the jury, it makes sense that some people will still view Whitehead as a pillar of the community with exceptional character, quote, or a, quote, person of integrity, reliability, and generosity who is compassionate, trustworthy, and kind. These are people who only see one side of the defendant, and as a result, their letters, like the defense submission itself, are most notable for what they leave out. They fail completely to grapple with the seriousness of Whitehead's crimes or the extent to which they were facilitated by the exact public persona on which the defense relies in seeking leniency. That is the precise species of argument that Judge Marrero correctly rejected in Riesenberg because it goes only so far and is flawed by what it omits. So then it goes on the applicable guidelines. Okay. Now, if you guys watched the other video with Whitehead's response or sentencing memo, he also mentions the conditions in the facility. So the government addresses that as well. Whitehead was first remanded on May 20th of 2024. At the time of the defendant's sentencing submission, he had been incarcerated for 2 weeks. So by the time he submitted that, where he was complaining about the conditions, he had only been there for 2 weeks. And as defense counsel knows, it is highly unlikely that the defendant will be obtained at the MDC for the duration of his sentence because he will be designated to another facility. Nevertheless, the defense attempts to rely on conditions of confinement at the MDC to justify a time-served sentence and release pending appeal. But the defendant's claims relating to the MDC are false, unsupported, unrelated to the defendant, and or outdated. First, many of the cases Whitehead cites are decades old and simply stand for the uncontroversial proposition that harsh conditions of pretrial confinement can, in appropriate cases, permissibly justify a downward variance. But that proposition is not in dispute here. Second, the more recent cases Whitehead relies on are inapplicable because they focus on the difficult conditions of confinement during the height of COVID, or because they focus on health risks an elderly and infirm defendant would face if detained in the MDC while awaiting sentence in the context of a bail motion, not a sentencing. Third, certain of defendant's complaints about the MDC are false. For example, the defendant claims that shortly after he entered the MDC, the facility went on lockdown because an operable firearm was recovered within an inmate cell. The government has conferred with the BOP counsel and confirmed this claim is false. No firearm, let alone an operable firearm, was found in an inmate cell in the MDC. I know you didn't just make that up and say that some GUN made it inside and you had to be on lockdown and all they had to do was call to confirm or deny. I can't. Bishop, honey, they left no stone unturned. It's no guessing. And then if you wanted to go back and rewrite and refer and reread, it's a whole table of content. So you can go back to that. Oh my goodness. Fourth, other claims Whitehead makes about MDC are simply irrelevant. He asserts that in the fall and winter it is cold in the facility and inmates are not given sufficiently warm clothing or blankets. But as noted above, Whitehead's detention at MDC began in May of this year. That's what I said. I was like, why are they talking about the winter? But I guess you got to do what you got to do. Argue how you can. Fifth, a number of Whitehead's claims about the conditions at the MDC do not support leniency in this particular case. He claims without any support or citation that the MDC's medical department is understaffed and medical treatment is sometimes delayed, but he told the probation office he was in good health and he only arrived at the MDC a few weeks ago. So basically, why are you concerned about the medical facility? you fine. He complains of the lack of programming at MDC, but as just noted, he will not be at MDC for long. To be sure, a number of courts have recognized and the government has acknowledged that there are serious issues at the MDC, and the MDC is making efforts to address, and in some cases has already addressed, complaints discussed in the defendant's submission. But the defendant has not been at the MDC for long and will not remain there for long. The conditions of this brief confinement pending sentencing do not justify the extraordinary leniency he seeks. So then it has the fine within the guidelines range is warranted. The defendant must pay restitution, forfeiture, and a special assessment. Consistent with the probation office's recommendation, the defendant must be ordered to pay restitution on count 1 in the amount of $85,000, forfeiture in the amount of $90,000, and a special assessment of $500. So for those that were asking, if Miss Anderson can get her money back, well, they're going to order it, but will he get it? Will she get it? I'm sorry, I'm not sure. So the government in the footnotes say they intend to provide the court with proposed restitution and forfeiture orders at sentencing. There is no basis for bail pending appeal. And so they feel like he shouldn't be able to get out on bail pending his appeal. In conclusion, for the reasons set forth above, a sentence of 151 months imprisonment and a guideline fine would be sufficient, but not greater than necessary. So they are requesting 151 months for the Bishop Whitehead. Now, Miss Anderson, she also attached, and I think in the brief that I just read, they are requesting that, I guess if she chooses to, or if her son chooses to, that they be allowed to actually speak at the sentencing, which is scheduled for the 17th. She actually did this is the impact statement from Pauline Anderson. Since May of 2021, my family and I have endured an indescribable amount of emotional, mental, physical, and financial suffering since Mr. Whitehead took my $90K. I lost everything I had worked for, including my extra funds, which I had to use to cover my over $40,000 in legal bills and penalties for taking an early withdrawal from my retirement fund, which included both federal and state. The anguish associated with having to repay taxes on funds the accused personally spent while I was left with nothing is indescribable. In January 2022, I had surgery, after which I spent 4 months on disability, earning nothing. When I returned to work, my pay was deducted for 6 months for owing state taxes on the $90K. All of this has resulted in a mountain of debt that I have been attempting to repay for the past 3 years without success, leaving me in financial devastation and difficulty. Then the defendant didn't believe he had inflicted enough suffering, proceeded to sue Rashid and myself, adding to my financial woes by forcing me to get a lawyer and find more money to pay for their services. So Whitehead ended up suing Rashid and Miss and Pauline Anderson, I think, for defamation. I thought that was contact with witnesses personally, because that's kind of jacked up. I mean, it seemed like it should have been something for that, but hey. The emotional and physical turmoil was the hardest. I couldn't sleep at night, and when I did, I woke up for hours thinking about how I had innocently and trustingly handed the defendant $90,000 to invest in a property for me to live in. I was also recovering from pulmonary embolism, the worst disease I've ever had, and being cheated out of my life savings during this time broke my heart, spirit, and soul. I was gutted. How could I pick up the parts of my damaged self, return to work, and sympathize with the individuals I serve? How do I help my patients cope and make decisions that affect their treatment while I am facing not just the worst illness of my life, but also the worst person to ever take my money? I couldn't even tell some of my family members what was going on because I didn't want them to be frightened, lose hope, or become angry at me for allowing myself to be in this predicament. It was difficult for me to maintain my calm at work, and I eventually had to take medical leave to deal with my sadness and loss, both in terms of health and financial loss. I wondered myself 100 times how I had gotten here. God, why would the accused spend the money on anything other than what was intended? With no place to live, my sister was dragging herself up 3 flights of stairs after suffering repeated hemorrhagic strokes, which left her with reduced vision and limb paralysis. My mother, who was aging and experienced mobility concerns, was also physically challenged. This $90,000 was meant to get me a house, the pinnacle of my efforts and sacrifices, and proof that even a single mother, I could succeed. Thank you for allowing me to speak, Your Honor. I seek restitution for the money the defendant has taken. I am in great pain. Couldn't even muster the courage today to relive this experience because of the defendant's activities. He continues to insult my family and myself by denying any wrongdoing and refusing to accept responsibility. I implore the court to take into account how this has affected my family and me. To conclude, I will quote my all-time favorite song and tell the defendant, quote, by God's Spirit, I will rise from the ashes of defeat. The resurrected King is resurrecting me. That is from the victim, Pauline Anderson. He is really a straight up.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh?
I'm not gonna call you
Look on Facebook Live.
Yes, sir.
Call me a cardboard bishop now.
Yes, sir. Yes, sir.
Clown. That's what you are. You clown. That's what you are. Why don't you say what you said on Facebook Live, sucker?
Yes, sir.
No.
You got it?
Thank you so much, Miss Renee. Thank you for the Cash App. Bridget, thank you for the Cash App. Natty, thank you. Alicia and Faith Speaks. I appreciate you supporting the platform. I hope you guys enjoyed this super long live, because that's what it is when we talk about Whitehead. But the first 30 minutes, for those of you that came in a little late, I was discussing that YSL shenanigans. I'm sure there'll be more. And maybe we end up making a second live about that in the near future. You know what? Cupcake says she would like to go to sentencing just to call him that. It would be crazy if the judge let the gallery come up and talk, because I probably would say something. Your Honor, I have a couple of words. I've got a few things to say, but I'm not a victim, you know. But yeah, I've talked to a lot of people, and the fact that according to this, you get off of parole in 2017, but you have things of which you were doing people wrong almost immediately is this nuts to me. And so I agree with the government. If that's the case, yeah, what is going to deter somebody who already had the opportunity to get it right after the first time? What would be a deterrence? Mhm. Like what would be somebody help me out here? What do you do with somebody like this? Like if you go to jail, because 6 years, maybe 6 days would have got me together. But like you look at stuff like this, and I went over a lot of this before. This was in '08 where he got a judgment against him, where he was accused of basically taking money from somebody. This wasn't even a part of what he went to prison for. Went to prison for the first time. It was just so if you just looked up his name, there were so many different things that were there. And they put Lamor Whitehead, aka Lamar Whitehead, individually in Anointing Management Services LLC. In that case that I just showed. So he been doing this Anointing Management LLC for a minute. And in that case, he was accused of wait a minute. In that case, I forget this stuff. He was accused, so they got Lamor Whitehead, aka Lamar Whitehead, and Anointing Management. So he's accused on or about June 27, 2007. Plaintiff tendered the defendant a loan in the sum of $200,000 in exchange for a note. The note was executed by the defendant at the plaintiff's residence where the transaction occurred. The note sued upon herein was given by Lamor Whitehead individually and Anointing Management Services to plaintiff, reflecting a promise to repay the loan of $200,000 plus $25,000 plus all fees included for a total of $225,000. The note is dated June 27, 2006. The defendant failed to make payments after August 1st, 2007. Demand for payment has been made and refused. The note provided that the defendant would pay all fees pertaining to the transaction imposed by plaintiff's home equity line of credit at National City Bank. So the plaintiff took out equity on his house to get his man $200,000. On or about June 27th of 2006, the defendant represented to plaintiff that in exchange for the loan, defendant was going to utilize the funds to purchase, obtain, and create a title insurance business of his own, and further represented to plaintiff that he has sufficient and ample personal resources of his own to pay back this loan in full within approximately 1 month's time. Ain't that what he told? He told Belmonte that when he was asking for $500,000 in order to talking about hard lending money so that he can fix up the building in Connecticut. That such representations by the defendant were false when made, and in truth, in fact, the defendant did not have such resources and did not utilize said funds to create, purchase, and obtain a title insurance business. That Lamar Whitehead did not use and invest the money in Anointing Management Services thereof as he represented. The plaintiff did not discover the true facts with respect to the false and fraudulent representation of the defendant until on or about November 30th, 2007. Nor could the plaintiff with reasonable diligence have discovered the true facts prior to that. Upon information and belief, the representation made by Lamar Whitehead and Anointing Management in regard to their promise to repay, as well as their ability to repay the loan, or that the defendant use of such sums were to further and invest in their business, were falsely made and were made with the pretense of actual knowledge when such knowledge did not actually exist, and or were made recklessly and without with regard of actual facts. Oh my That seemed like it should have been a part of that first go round, but then there was a time where Lamar Whitehead sued um where Lamar Whitehead ended up suing what's that? BMW, I think it was, saying that y'all got to see this. I can't make this stuff up. He sued Rose, defended BMW Financial Services, said plaintiff has a loan with defendant with the account, and it had for a 2017 Rolls-Royce Dawn. In August of 23rd, 2022, plaintiff called defendant to check on the status of his auto loan payment. Plaintiff was uncertain of the repayment status and inquired as to whether he was up to date. Defendant's agent, Sonji, told plaintiff that he was current and no payment was due. But August, plaintiff's call with defendant's representative took place on August 23rd, 2022, about 1 to 2. According to Sonji, the August payment was only 2 days late and the July payment was paid. Therefore, plaintiff was confident that he was not subject to being over 30 days on his loan. Plaintiff was later alerted that defendant reported a 30-day late on his consumer credit report. Defendant reported plaintiff 30 days late on the July 2022 payment, which it said was paid. Plaintiff was shocked and dismayed to see that his credit score dropped by 70 points as a result. Defendant's reporting caused catastrophic consequences on plaintiff's financial transactions. Plaintiff has requested that defendant correct its consumer credit reporting, but it has refused. Count 1, defendant is liable to plaintiff for negligence for the above alleged conduct. This is the type of lawsuits he was filing. We could be on and on about this guy. But anyways, guys, hope you guys enjoyed the live. I have to eat something. I'm sure you guys probably heard my stomach on this live. Hopefully we will be back soon. I'm sure the defendant will reply to this because they get to have the last word. I guess the judge is going to let them reply, I believe. I think they have to do it by the 13th. And then the sentence is on the 17th. Again, thank you to everyone that has supported the platform by hitting the like, subscribing, or even financially. I appreciate that. And yeah, I gotta go. You guys have a fantastic day. And I'm gonna holler at you guys next time.